issue has come up on the Commonwealth side that we might want to address first. I don't want to stick my oar in for the Commonwealth, but I know the court's unfamiliar with what I'm referencing. I understand it's kind of a big issue. It might drive the boat today, so I don't want to put the Commonwealth in the starting blocks before they're ready, but it might be the way to start is to take up this issue of some newly discovered evidence.
And again, Mr. Shouse, we don't disagree with that. There has been an issue that's come up with regards to some discovery. As it turns out, not all the phone data has been provided to the defense, but we are in a position where we can provide that today pursuant to the protective order. And the reason why our lead officer on the case knew there was child pornography on some of these phones. And your order was no porn. And when he redacted it, not everything made it over to the extraction disk. But we have those today and we can provide them. Okay. The disc contain the text and the instant messages, but not the images and movies. So communications were provided, but not video and things of that nature.
All right. What's the upshot of that? Have you, gentlemen, ladies?
Well, okay, it's a bit more it's a bit more involved than I think Mr. Heck. Let's back up a minute, Judge. And I'm going to do my best to go slowly and methodically where we are, without try very hard to maintain my composure. Here's where we are, Judge. It's over 50 gigabytes of data at 6 o'clock Friday afternoon, and I'm not blaming Mr. Heck, Ms. Kinzer, or Ms. Cole personally, but it is the Commonwealth's obligation to comply with this court's discovery orders. You, even before the protective order was entered, said, turn over everything. At a hearing on this case over a year ago, you said, turn over everything except the videos. Then, even granting Mr. Heck the benefit of the doubt, once the protective order was entered, and it was clear that any issues of questionable images were covered by the protective order, we should have gotten it then. So let's talk about what we're talking about here, Judge. We're talking about over 50 gigabytes of phone data from all the phones in the case. Not just Mr. Miller's, Mr. Jones, Mr. Kavanaugh, all the phones, including some witnesses. Next, by Mr. Heck's own admission, we didn't get what's called a Cellbrite report on any of these phones, which is the basic report on what's on the phones. Next, as I've alluded to, at 6 o'clock Friday afternoon, Mr. Heck gave me the name over the phone of 3 experts that I have never heard before who did all of the testing on these phones. I'm sure the Commonwealth will correct me if I misstate what I'm about to say. My understanding is this. These phones were taken to Nashville over a year and a half ago, where people we just learned about on Friday night did testing. We haven't received the results of any of that testing. Further, the data on the phones was manipulated in such a way that it can be presented by the Commonwealth in a manner that we never got. And that manipulation, Judge, is the product of an individualized computer program written by one of these 3 fellas in Nashville that's never been used before, to the best of my knowledge. So we got a huge Daubert issue right there. Some guy in Nashville writes a little program to manipulate the data because the text messages aren't the way the Commonwealth wants them. Oh, and then he writes this program and here they are. They can't authenticate any of this. Judge, the Cellbrite reports should have been turned over 2 years, well, we're not 2 years yet, almost 2 years ago. There's a whole host of questions. When was this test? One question that I would ask right off the bat is, when was this testing done in Nashville? When was all this stuff produced? I'm going to guess sometime in 2015. We're 9 business days out from trial as we stand here, Judge, and we still don't have it. Now, again, I want to give the Commonwealth credit. They can't give us some of this until you order them to because of the protective order. Their position is, and I don't want to argue their case for them, but we need the judge to say the protective order covers this too, and then they've got these external hard drives ready to give to everybody. It's thousands of text messages, thousands of images. And by their own admission, they have manipulated, and I don't want to put too strong a word on it, but I don't know another word. They have made the data through this program to put in a position that is helpful to them. I have no idea what any of that is. I've not seen any of it. And we learned of this 9 business days before trial. Judge, they can't give us this now. It's out. It's a violation of this court's discovery order. It's a violation of this court's specific order with regard to this case, saying, turn everything over. And then the protective order even screwed that down harder. Then we had to go to the Court of Appeals on that. Also, without putting too fine a point on it, Ms. Pryor, on behalf of the Commonwealth, the last time we were here, told the court, I have spoken to the Attorney General's office. They will be ready to go on October 22nd. And she implied that
August 22nd.
What did I say? October, I'm sorry. That's another trial date I've got with Ms. Pryor. August 22nd, the Attorney Generals will be ready to go. Ms. Pryor said, I have spoken to the Office of the Attorney General, they will be ready to go, and went on to tell the court that she thought that our arguments to have her removed were nothing more than a charade to continue the case. Judge, they're only bringing up this issue because they don't want to go on August 22nd. I also want to point out that on behalf of Mr. Miller, we filed a speedy trial motion on October the 1st of 2015. All 4 of the factors that the court must consider on whether or not his rights to a speedy trial have been violated weigh in our favor. Invocation of the right, yes, October 1st, 2015. Cause for the delay, all the Commonwealth. We've never asked for a continuance in this case, Judge. We're not asking for one now. We're ready to go, and they drop 50 gigabytes of evidence on us, which I want to point out, I still don't have it, and I agree their position is not, it's not unreasonable, the position they're taking. But it's mammoth, Judge. And we have to get to the fact, we haven't even really addressed the point that their expert, and Mr. Heck told me straight up, again, I'm not criticizing Mr. Heck at all, he told me straight up that their own forensic experts in Frankfurt question whether or not someone could create an individualized program for a specific case and have it fly under Daubert and Kumho and everything else. So our position is that it's a little more complicated than the Commonwealth said just then. It's a mammoth amount of information. The Cellbright reports can't possibly come in. It would take a long time for an expert to look at that. None of this other data, none of this data that was influenced by this program some gentleman whose name I don't even have in Nashville wrote. So with all due respect to the Commonwealth, I don't want that external hard drive. I want to go to trial.